we just went and did an introduction of everybody in the room. It might be kind of nice. Xavier, do you want to start?
I'll start. I'm Xavier Ward. I'm a reporter with Idaho Press.
I'm Marissa Keith. I'm president of the Southwest Alliance Neighborhood Association.
Who are you? Yeah.
And how did you get in here?
Natalie Tabor, public information specialist for ACHD.
Okay.
I'm Kenny Wirth. I'm board member of the Downtown Neighborhood Association.
Oh, great.
Paul Daigle, chief of staff.
Stacy Spencer, secretary of the board.
Bruce Wong, director of ACHD. I'm Steve Price, general counsel. There's my lovely assistant, Graciela.
Perfect timing.
She's bringing copies of the 80-page PowerPoint presentation.
Oh, boy. I'm sure you did that.
Okay.
Kent Goldthorpe.
Thank you. Brett Arnold, Commissioner. Mary May, Commissioner.
Jim Hansen, Commissioner. One.
Welcome everyone and welcome to our guests.
Thank you.
And they will pass them around. They're nice and warm. They just came out of the oven. And, you don't have to go through them, but I thought sometimes people like to make notes or draw question marks. And Commissioner May, my style is pretty fluid. If you have questions as we go along, that's fine. When we get through an area of discussion, then I'll do kind of a final call. We'll have any questions, and then we'll move on to the next one. And today I have been directed to speak as to the oath of office, the commission protocols, ethics, and our upcoming adoption of, or consideration of adoption for social media policy. And first section will be, okay, there are the four categories: oath of office, commission protocols, ethics, and social media. There's an overview of the oath of office. We're going to look at the Idaho law, our current policy, what's required of commissioners, what are the consequences for violating your oath of office. And we're going to look at other states as well as the federal government on how they deal with violations of oath of office. By the way, I did not set the agenda. I was asked to provide it. So, prior in Idaho law, every commissioner and officer must take an oath of office. That's within the Highway District statute. That they will take and subscribe the oath of office, which shall be then filed with the office of the Highway District Commissioners. Subscribe, the word means you have to sign it. The officer shall take and file, if this relates to a single county-wide highway district, that will take and file with their secretary the oath of faithful performance of their duties. So it's basically the same within just your generic highway district commissioners, and within the single countywide highway district. And Commissioner May, the one thing under Idaho law with highway districts is originally 40-Chapter 13 relates to just all highway districts in the state of Idaho. And then when ACHD was created, there was a single countywide highway district. And the statute, enabling statute, that is for Chapter 14. And then there's also a bridge between the two statutes. One basically say, in the single countywide highway district, if it's not in this statute, then we'll incorporate what's in Chapter 13, so it's fairly comprehensive. So you'll see me refer to both the generic highway district commission of Chapter 13 and 14. And there's Deanna Smith. Welcome. Failing to take the oath prevents an elected official from being qualified to hold office. We actually had a 2010 case on that. The state statute, Title 59, defines what the oath will be for all elected officials within the state of Idaho, and there it is. ACHD, or when do you have to do it? You have to do it within 10 days of notice of election or appointment, and if no notice is given, 15 days before work begins. we satisfied that, within the first meeting, of the commission after your appointment or your election. So this year you did it on the 9th. Who do you do it with? Well, you can do it with anybody that's qualified to administer oaths. You file it with the Ada County Recorder, and then we keep a copy here. Also within our ethics policy that was adopted by the commission, it's been amended over time. The ACHD oath goes beyond what the statute requires. And you'll see here that the language that's in bold, that the elected official also swears that they will support not only the Constitution of the United States and the laws of the state of Idaho, but also the rules, regulations, and ordinance of the highway district, as well as faithfully discharge the duties of the Ada County Highway District Commission according to the highest ethical standards, to the best of your abilities. And so that is something that that the commission in the past has included within our ethics policy, and that is the oath that you took.
That's a question. So an appellant comes to us and says, we have a different interpretation of your ordinance. Legal counsel for our staff says this is our interpretation of our ordinance. So we have two presentations. My view is that we are an independent body. We are sitting in a quasi-judicial capacity. But you could say this oath says that we must interpret the ordinance according to our staff's interpretation of the ordinance, which means we cannot independently evaluate and interpret the law.
Well, you know, there's kind of an atom splitting exercise, but
well, it's come before us before.
no, there's no doubt about it. I mean, I think that you have to rely upon the technical experts of your staff and the advice that they provide to you. If I provide you a legal opinion, you don't have to follow it.
But according to that, the interpretation of the oath is we have to follow
To
it.
the best of your abilities.
But
Yeah.
if legal counsel for an appellant says, no, we interpret this differently, as in any legal case, you're sitting quasi-judicial. So that basically says, are we like the judge, or are we like one party? Are we like the judge in this, in which case we view the two parties as providing equal information for us to evaluate as
I think you have
Is that correct?
I think you have the flexibility to do that.
to do that.
Yeah,
We
but
are not obligated to say, we have to.
You have the ability
we have
to interpret the ACHD rules and regulations as a body. And if the body makes a
As a
decision.
judicial body,
Yes.
right, okay, I wanna make that clear, because I don't think that's what I would assume, because we're sitting as an independent body.
Well, yeah.
Evaluating, and the staff, including the staff's attorney, is one of the parties providing us an interpretation of an ordinance.
But as the
And
body,
we
the
have the
body,
ability to change that ordinance at a subsequent date, but as to this case, we have to evaluate that.
yeah, but as a body, the majority dictates what that standard rule is.
Sure, it's a panel of 5 judges,
Right.
so, but it's not a violation of our oath to interpret our ordinance in a way
course not.
that is different
No.
than the legal counsel for our agency.
No.
I wanna-
Not at all. I give you advice all the time that you guys ignore, that's why. And I'll defend you, so that's, I most certainly understand that.
I just wanna make it clear, because
Yeah.
sometimes there's a perception out there that we represent the staff,
No,
and that they must overcome
No,
not
the
only the
staff
staffs,
support you.
but the commission. And I wanna make it clear, we are an independent body, we represent the taxpayers who elected us.
you
not-
represent the constituents that elected you.
Right,
And your director and your legal staff and all of your technical staff, there are for your support.
right.
That's it.
And in a judicial case, they're one of the parties.
Yeah.
But what you're saying, Steve, is that the majority dictates what the ordinance means.
Right.
So, I mean, you can make that determination, but you can't just disregard or ignore
Exactly.
a rule or an ordinance. If you don't like one, you know.
You change
you
it,
can
and
change it.
we'll get into that,
We can change
how you
it.
do it.
Right.
Additional requirements, the ACHD policy does not require that the oath be signed, although the state statute does. And that it has to be taken in front of someone with the authority to administer oath. So, but we do anyway. We follow both the state, and since our policy on oath is really an addition to, we follow both the state and our policy. It is a public record, and people have filed public records requests with Stacy, and we provided copies of that. And it's a copy it is our policy, but we do all these things. The copy is kept in our ACHD offices. But again, our policy requires the commission to read and accept it, and it's the requirement to sign. So when you take these, this is kind of just reiterating. You have to follow the Constitution, uphold the Constitution of the state of Idaho, our rules, regulations, and ordinances. Discharge your duties to the highest ethical standards, and faithfully discharge your duties to the best of your ability. We're all good with that? Pretty simple. Now, I would like to get into the rule of law, what the rule of law means. And what that means is that as elected officials, you have an obligation to follow the rule of law. It doesn't give you the authority to, because of your particular political agenda or anything like that, to completely disregard it, to advance that political agenda. If you want to if you want to advance a public policy or political agenda item, then you go and you change the rules, the regulation and ordinances, and we'll get in how you can change that. But you all have an obligation under this oath to follow the rule of law.
So Steve, in instances where a development application comes before us that meets all of our policies and all the state requirements, we wouldn't have a legal basis to turn that down. So is it a violation of the oath of office to vote no under that circumstance?
Well, it most certainly can be argued that, but in those decisions, you have a record with facts. You have also the standards of our policies. You may have different interpretations of what those policies are. So it really depends on what's in the record as to what's been determined. There may be a question about our particular standard and how it applies to the fact pattern. So I hate to just say yes, but it really relates to the discussion. The facts that have been put into the record is a quasi-judicial setting. We're sitting in the capacity as judge and jury. It's important that we have established a record for an appeal, that the record is not tainted by a violation of ex parte communications. The record is that we make sure that we get all of the correspondence and information from the public and testimony that's been submitted and included in the record. Stacy is responsible as secretary to make sure that the record is complete. It's also my job to make sure that we make sure that we have everything that's in the record, and that if we have any ethical issues with ex parte communications, that they're disclosed and to the commission and to the public, and that we have full transparency as to the facts. Then we have to make decisions solely on the facts that are in the record and that are based upon the law that's basically agreed to by the commission. So that's what you guys do. That's your responsibility as you sit in a quasi-judicial capacity as judge and jury. So I don't think that there is no canned answer on that. I think it's really have to review it on a case-by-case basis. And how good of a job you guys do in getting all the facts into the record. There may be assumed facts that don't get into the record that may represent a basis for denial, even though it appears on the face that the developers complied with all of the requirements of our policy. If some of those facts aren't into the record properly, that would be also a basis for the denial. I'm only stating that as an example, is that sometimes that happens. But it's my job to try and make sure that we get all those facts into there. And sometimes I haven't done it, and I don't say anything, and I've never been caught, so.
So we have to find adequate facts. Because
Yes.
we have to be finders of facts, and if the
Yes.
facts aren't adequate,
Exactly.
we believe, as individual commissioners, the facts aren't adequate.
Yes.
And then those facts that are presented to us have to be available to all the commissioners and to the opposing part, to the various parties. So communications with the commission that's not available to the parties before us, shouldn't be for. That's why I have questions, I raised it with you, of the director's memo to us, usually the night before a commission, that restates what's on the agenda. But those are interpretations of a staff report, and, you know, it's fairly minimal, but nonetheless, that's a piece of information that comes to us as judicial body that the other party hasn't had, and so that's a form of communication from one of the parties. And whether that's appropriate, whether you've already made a determination. That particular one, it's not inappropriate for the commission to receive that information as they deliberate as an independent body, even though the party on the other side hasn't seen it.
Well, and I don't receive the memo. The times that I have not seen it in any instant where it has provided anything other than the general tenor of what the meeting is going to address. I don't think it expresses facts or law, but we can be more careful about that. If you think that that's happened, I'm most certainly happy to work with the director and sanitize those transmissions. And also make sure that they're part of the record. That's another safe way of doing
I
it.
think that would be a good safety mechanism,
You
and
bet.
make sure the parties get it. You know, it's not necessary because we finished reading the whole record. We've all read all the materials in front of us. It's just a little way of saying, this is a good way of interpreting this particular issue in favor of the staff, which is a party in a judicial case,
That's fair.
as is the appellant.
Fair enough.
And we need to, just like it probably wouldn't be appropriate if the appellant sent us a little summary email the night before that said, you know, this basically is what I said in the record that you've already got. We have to treat the two parties in the quasi-judicial cases as equal and
No,
independent.
absolutely. I think we do a good job with that, to be honest with you. That is most certainly one of our missions. The other thing, let's just give you an example, is that when we have a quasi-judicial, and we're going to get into that in a minute, we're kind of jumping ahead for you. The commission sits in two capacities. One's legislative, one's quasi-judicial. Legislative is when you're adopting policy, ordinances, and regulations that apply generally to all of the citizens and constituents of Dade County. And so, and that is sometimes just a portion of a regular meeting. And then in the quasi-judicial, it's like development applications when it involves somebody's property. They have a property right, a fundamental constitutional right for what to do with their property, and the decisions that you're making is affecting that property right. And so you sit in a different capacity, and there's a whole different set of rules that you have to apply between legislative. And so if you get ex parte communications on legislative items, that's fine. You're in a legislative capacity. It's like going down to the legislature and you're sitting in that capacity, and they want actually in that capacity, you want to hear from your constituents about what they think, what the public policy ought to be, what is good public policy. But when you're in making a decision about somebody's property in a quasi-judicial capacity, you sit in a judge and jury capacity. It has to be fair. It has to have due process, both substantive and procedural due process. You can't have ex parte communications. You have to have a confined record. You have to treat everybody equally within the process. But one thing you can't do that everybody does, they're not supposed to do, is in your reviewing is to drive out there and look at the development. Because why? Now you're considering facts and information that the other four of your colleagues on the commission aren't seen. And so, those field trips, I mean, there's a procedure under law if the commission wants to go as a body
Just don't.
and look at it. The other thing that staff has done is we'll go and we'll take a video and we'll drive down the road, and like Sherman Hollow, we did that, drive down the road and put it up on the big screen, and you all then get to assess from a video, but it's in the record. And so that just gives you an example. It's just, I'm only using that as a way to explain it, that within the quasi-judicial, you want to make sure you have a tight record, that you're not taking stuff outside that, and also that you're not making predetermined decisions about that. You have to look at each one with all the facts of that particular property, and also what the law is as it relates to that, what our policy for that particular piece of property. Okay. So, oath breaking is not directly addressed by Idaho, but there's some indirect consequences. If you're convicted of a felony or any public offense involving a violation of oath, that creates an automatic vacancy. That's a 2010 case you go bye-bye. Whenever an officer is convicted of an infamous crime or offense, you'll have to ask Stacy what that means, involving a violation of oath of office. Notice must be given to the officer empowered to fill the vacancy. Failing to honor the oath means that duties were not faithfully discharged. We have another criminal statute, Title 18. Every willful omission to perform any duty enjoined by law upon a public officer or person holding any public trust or employment. We're going to get into that too. Where no special provision shall have been made for the punishment of such delinquency as punishable as a misdemeanor. That's not much fun. You don't want to. Oh.
Has that actually happened?
We haven't found any cases, no. And then we have another one for, it's in really the county statute. Any commissioner who neglects or refuses without just cause therefore to perform any duty imposed on him or willfully violates any law provided for his government as such officer or fraudulently or corruptly performs any duty imposed on him or willfully, fraudulently, or corruptly attempts to perform an act as a commissioner. Unauthorized violation shall be guilty of a misdemeanor. That's, I'm only giving you examples. Other states, they take it a little bit more serious. You violate your oath, it's punishable like perjury. Oh. In Georgia, if it's willful, you can get imprisonment, not more than one. Excuse me, less than one, but not more than 5. In Washington, you're subject to a 10-year statute of limitations. So you could be out of office for several years and wham. And your just talks about other violations. I prepared this a couple of years ago for some legislative people. Here's some other deals, and then federal law explicitly makes breaking oath of office a crime. It talks about what the requirements are. There are different ones. Removal of office, a fine, imprisonment of not more than a year and a day. So anyway, that gives you what your responsibilities are. Oath, you all take it. You have to take it. Any questions on oath? Is that what you were looking for?
Yes. Just make sure we all
Oh, good.
understand that. Very good, thank you.
Jim, anything else?
Yeah.
Okay. Now we're going to get into our protocols, commission protocols. I've handed it out to you. You should have had this. It's been around since June of 2012. So this was a long time ago, within 15 years. They originally adopted to avoid conflicts and entanglement over commission business. If you can believe it, that actually happened. That's a joke. And through the adoption of our resolutions, they are binding upon the commission and only can be enforced by members of the commission. So this is a self-regulating resolution. The most recent amendment, I guess, was 2011, Resolution 980. And again, they're binding upon the commission and can only be enforced by, and they can be amended at any time or repealed. So there's a whole bunch, there's about 20-something pages in the book that I provided you that were part of the resolution. And these are all the different categories: meeting, rules of conduct, quasi-judicial proceedings, public meetings addressing the commission, public hearings, policy-making process, commission administrative support, meeting cover and public relations, that's right, and miscellaneous provisions and standard of conduct. And I picked out key points within each of those categories. We're going to review those, but I kind of went through some of the ones. And Commissioner May, because you're the rookie, some of this may be repetitive for the other commissioners, but it also might be a good review. So, really, in terms of conduct during the meeting, the commissioner will limit his or her comments to the subject matter item or motion being considered by the commission. The commissioners will govern themselves to the length of their comments or presentation. Tie votes resulting in the lost motion, don't they, Ken?
Or abstinence.
Yes. Serial meetings, that's a meeting at any one time will involve only a portion of the commission, but eventually involves communications between a quorum. The process deprives the public a meaningful opportunity to be involved in the decision-making process. This is something that is probably the most serious violation of the open meeting law. And we are pretty vigilant about it. Quasi-judicial proceedings versus legislative, I kind of went through that. Legislative, again, we're adopting ordinance, resolution, or other policies. It's a legislative action. Quasi-judicial is a proceeding in which the commission is required to make a finding based upon the evidentiary record. You sit as judge and jury, you're required to make findings based upon the evidence in the record. And commission applies specific facts of the matter to the standards provided in the policies. And again, this relates to parcels of land, access, and various staff decisions. And one thing I wanted to comment on that is that when we do a waiver of policy, there are, in our policy, let's say in a development, maybe you're sitting in a quasi-judicial capacity, there are specific criteria that are in our policy that the person asking for the variance or waiver has to establish in terms of evidence. So there has to be a specific finding. If you're granting a waiver or denying it, we have to go through that. And when we have that come up, we provide that in the staff report. So the decision needs to be very tight as to the specific findings. I'm only giving that as an example, as to give you an idea that, and not only that, we'll provide you that, and Commissioner Henson's very conversant in what those, he's pretty vigilant about sticking to what those criteria are.
And we deal with a lot of budget issues. You don't actually say budget is legislative, but everything we do in terms of the way we spend money and prioritize money is legislative.
Yeah, because you're reaching all of your constituents.
Right, even though it might, a particular budget item might influence and affect a set of property owners at an intersection or on a roadway, it's actually a legislative action. And so those are governed under the legislative action rules.
So again, you may have communications outside the open meeting to discuss legislative issues without concern of violating the open meeting laws. If you do, though, I usually take a very conservative approach and have them disclose those communications at the adoption of the legislative item. I think it's just a good idea so that the public knows that you've been talking to other people and what their input is. You don't have to, but I think it's a good practice to be transparent. Quasi-judicial, these are ex parte communications that's conducted outside a public meeting with any person. When that happens, you must disclose, the decision has to be confined to the record, and all of the commissioners should be based upon the same facts, the same record. But when you do have those, you must disclose the details of that communication for the public record, so you can still have ex parte communications. I don't recommend it, but when you do, they happen. People call you up and they got you, and you know, you usually just refer them to come and attend the public meeting. Everybody here does that, and send in a letter or provide their input that way, so all the commissioners can get that advice. And so that you have to disclose it, and once you disclose it, that's fine. But we like you to disclose as to the substance of the communication, the date, you know, the details, some of the salient points. But generally, I would stay away from getting into any of the details. Just have them comment or write the statement to all the commission. That seems to have worked. We've never had an issue that I can recall. We've had a fair amount of ex parte communications. The commission, they come and ask me, they disclose it, the general tenor of what's happened, and the people have then either shown up or they provided something in writing. So it works well, but you really have to regulate how you get those communications.
Well, and even if a disclosure is not required, I think it's always better to disclose it. I mean, I do too. It's more transparent.
So there's a difference between, there's a lot of confusion, and I always kind of giggle. There's a big difference between public meetings and public hearing. Our regular meetings that we have every week, those are public meetings, and there are different notice requirements about those meetings. They have different matters, and sometimes within a public meeting, you'll have a public hearing. And the public hearing requirement is typically whenever we adopt an ordinance. For instance, there's a statutory requirement that we have to conduct a public hearing, and there's a specific procedure that we have to follow that's designated by statute. With additional notice mostly published. There are some times where we self-inflict public hearings through our policy. We require it, and that's fine, but it is a state statute. We most certainly can conduct a public hearing if we want to. The state statute says the minimum requirements for when you have to conduct a public hearing. But in any event, there's the distinction between public meeting and public hearing. And when the president of the commission, generally when they open up the commission meeting, the regular meeting, if it's a public hearing, she'll say, I'll open up the public hearing. And the staff report should indicate when it is a public hearing. Okay, so we typically let you know why. And in the record, we have to show that we've got the publication, the dates that we've met the publication requirements, yada, yada, yada.
So that's a real important distinction, because the earlier discussion about meaningful participation of the public in the decisions that we have, and because we have limitations on ex parte communications, especially in quasi-judicial, there really needs to be, we can't have a public meeting in which we make a decision but don't provide meaningful public input. And at the same time, we're also saying we don't want the public communicating with us individually. So we really do need to have an open public process for meaningful public participation with all of the decisions.
Well, that's what our public meetings are for.
Right.
Yeah. And the notice that we provide. And
right, but I mean, we hold work sessions and meetings where we receive information from the staff, which is good. But it's at the public hearings where the public can provide, other people can provide input. And that's
but they can during a public meeting too, on items that they come in and talk about. Public hearing.
We don't allow them to speak in a work session or.
No, but that's up to the discretion of the president.
So we only allow them to speak if it's.
I see what you're saying.
Yeah. So a lot of the deliberation happens in a context in which they don't have meaningful participation. They have to wait until public communications at the end of the hearing if it's not specifically on an agenda. So that's one of the things I think we have to be sensitive to, is if we want meaningful participation by the public, we should provide as many opportunities for the public to give the information to all of us at the same time.
Right. And I think we do that. I think we go above and beyond what's required in that regard.
Absolutely.
We seem to have more.
We have public information meetings on projects. I mean, it's all within it. Yeah. And, yeah, and if anybody has a specific request regarding an item, they can make a rewritten request to the commission and have it addressed. But if it's on the agenda during a public meeting, the public is allowed to testify and provide input. And then the public hearing, they're allowed to. The work sessions, that's a different issue, but usually the issue that's on a work session, although they're not allowed to, will eventually come to the commission in a public meeting or a public hearing. And they will have the opportunity. They can always submit something in writing.
That's a good question, because we have public, open houses quite a lot. That's a really important
Yeah.
point at which the public provides information. And I've always taken that as an invitation to go to the open houses and listen, which is what I do. I go to quite a lot of open houses and just wander through and listen to the conversations that people are having with our staff and the consultants and so forth.
Well, that
now
depends. It depends.
That's
If it's-
information that's being provided to our staff, but I'm also hearing it and hearing the different views. You know, it's one thing to say, 30 people said yes and 40 people said no. It's another to know, these were the conversations that happened. that
Well, you and
informed
I have
our
got
staff.
crossways once before, and there's a difference. If you go to a public information meeting where it's one of our projects, which is more legislative, that's fine. But when you go to a developer's meeting over his property, and you're gonna be sitting in a quasi-judicial capacity, you will be taking in information
Right.
that's outside the record. And I advise you, and I've advised you not to do that.
Right.
And so,
Which I don't do. So now, information shows up at neighborhood association meetings, and I think that's part of our job, is to represent the people. And go to neighborhood associations, somebody shows up and says, I'm concerned about this project, and it might come up before.
well, if it
You have to
involves a
disclose
developer
that.
project, then you know how to deal with it. It's ex parte communication. You were
So
involved in it.
the temptation is to shut yourself off of representing your constituents.
But I don't think that, I hope that isn't the intent of this presentation.
Yeah, well,
No, I'm just saying, these are the rules you
Meaningful
gotta
public
follow.
participation.
Sure, and it's up to each individual commissioner, so, don't disagree. No, I think you know that I'm, always advocating for a very transparent public process.
yeah.
It's easy, it's conservative, and we don't get ourselves caught up in any legal issues. It's low risk, and it's part of the democratic process. You're a lawyer, Rebecca's a lawyer, I'm a lawyer. We know how important that is, so, absolutely. But these are the rules that we have to follow.
Oh, yeah.
And they're minimum standards, and if you wanna do more, great. So anyway, these are the, again, a public hearing is usually a portion of an agenda item of a public meeting. A public hearing is usually a legislative decision. That's when you're adopting an ordinance. Sometimes though, Commissioner May, we will, like I said, self-inflict a public hearing on some quasi-judicial thing. And I usually just let it ride, because the public gets to participate in both situations, so. Then within this section of our protocols, it talks about agenda presentation. I'm not gonna get into all the, I've only picked up some of the salient points. Public communications, that's at the end of our agenda. If you need to read those sections. And then there's miscellaneous matters relating to that.
Steve,
Yeah.
I wanna go back to the attending neighborhood association meetings. If I get an agenda for a neighborhood association meeting and they're going to discuss a specific development application that's gonna come before me, I tend to not go. Because I think it becomes a transparency issue if you attend those meetings and you don't, for whatever reason, if you're not able to disclose everything that's said there. I think it's a transparency issue if you're taking in that information.
Well, I don't disagree with you, but that is a stylistic thing for
To
the
a neighborhood
commissioner.
association meeting if I know a specific development application is gonna be discussed and it's gonna come before me.
Yeah.
Cause I wanna be completely transparent.
Well, but there's another thing that as the body, if it comes into the commission, and the commissioner's gone to a neighborhood meeting and they've had a discussion about development, they're vastly opposed to it, and you sat there and you listened to the whole thing. And when the disclosure comes out in an ex parte communication, if there's any other commissioner that believes that because of that there will be an appearance of fairness issue, meaning that from that communication, it doesn't look like that the commission can be fair in hearing it. Then the other commissioners can vote to require that commissioner not to participate and recuse themselves. So,
That's another risk of attending neighborhood association meetings, you know. when
And
there's
as you
specific
know,
development.
of course, all the neighborhood association meetings I've attended, there's no agenda until you get there. So I've left at a point where they've discussed something that I know is going to come up. Cause as far as my experience with neighborhood associations is you don't get those in advance, you're walking in, these are your constituents, and a lot of the discussion is general, what does the agency do, and who are you, and these are my general concerns, a lot of the same stuff you get in telesis. But if they then say, okay, we're gonna have a presentation by,
well, you can either leave or you can.
you just leave, you just say,
And then you disclose that
I'm gonna
happened.
leave.
That's all.
So, I've never actually received an agenda of a neighborhood association in advance. It would be nice if that was
Mine
the
does.
case.
I
Yeah.
got
We
them
do.
in advance.
Yeah, we do that. Not that they always stay on.
I know.
On track.
So public hearing, here's some of the big topic points. These are covered in pages within the protocol manual I gave to you. Then the policy decision-making process, there is a discussion about how we act in a legislative capacity. And again, it gets into the participation in community activities, work sessions. But there's a decision-making matrix that's in Appendix A and B in the protocols. And it shows, one is there's within that policy, within the protocols, there's a pretty two-page description of all the steps that go through to create a new or request a new policy decision. And then there's a matrix on page 20 and 21 that talks about that process. As long as I've been here, our commission has never followed that. They've usually said, hey, director, make it so. And then staff will go and we'll draft some language. And he says, Steve, make it so. And then I draft it, or Scott drafts it. And we present it to the commission, and hopefully we've gone in a direction that the commission wants. And we'll sometimes, Commissioner Hanson typically would like us to do a work session on that, which we try and do. When we do the work session, we take additional input, helps us in the drafting of the policy. We get, we allow public input on that when we adopt it. Before we even adopt it, we go out to who we think that the parties would be affected by it. The most recent one was the bridge design that you approved. We go to the BCA, we go to a lot of the engineers and consultants that use that design, even though we're currently administering it. And we get their input, and it's great input, and it's really important. The thing is, it's very, very good. It's nice to be transparent and do it, but at the same time, we like their expertise. We actually benefit from getting their input. So, yeah. So anyway, but if you really want to get into it, and if you ever want to follow the decision-making matrix, it would be so awesome, because then I could say that we finally did it.
Yeah, there's actually something in that I think that's really valuable, and that is because we are a mile wide and an inch deep. The context and understanding, it took me several years to really understand like what level of service was. So educational programs that are provided from outside of the agency that tells about trends. The educational programs put on by Idaho Smart Growth, by the Urban Land Institute, by the Walk Bike Alliance. There's educational programs. They are great.
Compass puts on some.
Compass does great educational programs, and oftentimes I'm the only elected official there, just so that I know, because if you don't know even how to ask the question, until I understood what, got into level of service and understood and said, I have a different view as to whether that's a wise policy.
I know, his first week here, he was calling them arteries and not arterials.
But that's right, and they're arteries and veins. But that's something I think that we have to be careful not to then avoid, well, the risk is we're gonna run across people who are gonna provide us information. We have to be, and then we become totally dependent on how our staff interprets particular, things like, level of service or some of the other, issues, and we don't sort of get, okay, we represent our whole community, what's the future of our community? What's happening in Omaha and in Minneapolis and in Jacksonville that might inform how we spend our taxpayers' money, and the
But-
standards and the matrix and the measurements and all those kind of things that go into it. And even to know, I don't know enough, let's get in some people to come and talk to us. Or to say, let's all educate ourselves on the new standards for example, I think the staff did a great job on the bike matrix. And they were the ones, that staff and the bike advisory committee pushed us to look at the new analyses that weren't in our previous version. But that was pushed from the outside, and we said, take a look at these are really good.
Yeah, no, and that's the way it's supposed to happen.
Yeah,
But we're fairly vigilant. You're gonna be getting all of those notices for all those type of educational opportunities. We send them out. It's again up to you as a commissioner whether you want to attend them. We have staff attend them. The other thing that we're very vigilant about is our staff go to national conferences. We're really big into that, where we go and we hold ourselves out as being innovative at the leading edge of transportation. They go to planning conferences and engineering conferences, and they bring all that back, and they have to document, what they learned, what are the new ways, and we evaluate all that, and it's money well spent.
It is important.
it is, and I think we should broadly understand some of those, the commission should be exposed to those
That'd be
training
important.
opportunities. There's one that it's kind of broad, but they do bring experts together, that the chamber brings together, Sun Valley and McCall.
Yeah, the jump
Leadership.
It's,
leadership.
Well, you then find out, there's experts from around the country, they can afford to bring them in. But Compass does some excellent
Yes, they do.
programs.
Well, in ACHD, we brought in experts to come and talk to us about growth, Freilich and Michael Laird, and we've done that when we've in the blueprint for good growth. We bring in our roundabout experts for the commission, so we're not afraid for us to come to the commission when we have a big new area that we're going to go into. We'll bring in the experts, and one of those that we've hired since 2017 is our ADA experts. We really got the gold standard in team out of California. They've been helping us, and we're seeing a lot of progress in the way we do that. So then here's another category within the protocols about how administrative support, mail, clerical support, request for research. There's a 1 to 2 hour limit that goes to the director, and then if it goes beyond that, then it goes to the president of the commission, and they decide whether they're going to expand staff resources to do that. There's a provision in there about your salaries. It needs to be a line item in the annual budget. And then expense reimbursement, mileage reimbursement, and all the travel, that's all part of the protocols and procedures on how you do your stuff. Media coverage, Natalie, this is, the one thing we struggled in the past is the reason why this is in there, is that the reason why we have a communications department is to manage the communications. And that we don't have commissioners going off left and right saying different things. And so really the communications department is a clearinghouse. The president of the commission is the spokesperson, official spokesperson for the commission. If any commissioner does talk to the press, that they have to make it very clear that it's not the official position of the commission, that's their individual opinion. They have a First Amendment right to talk, but we ask as a courtesy and for the best interest of the organization that you contact our communication department, that we be involved prior to. If you want a request for an interview with Xavier, we're most certainly happy to set that up. And we also like to at least know ahead of time, let you know when there's going to be a controversial or sensitive communication. We'll at least give the commission the quote incoming end quote So,
brief.
yeah, so you're fully briefed.
But what happens on that last one, it's difficult sometimes to make it clear with the person you're talking to with the media that you're talking as an individual.
Right.
Quite often, if you talk to somebody in the media, they may say, well, you know, they may take it as an official position,
As gospel.
even when you don't mean that
Yeah.
it is, so.
Now we've got some miscellaneous provisions. One is we have to have a quorum, so all of our requirements for open meeting law require we have to follow those. We can conduct meetings by means of telecommunications. Commissioner Baker declined my presentation. That's fine.
She's heard it quite a few times.
Yeah. And anyway, so here's some stuff on privileged communications. Any information that's disclosed during the executive session shall not be disclosed to a third party without prior commission approval. Attorney-client work product exchange between attorneys and the commission will not be disclosed to any third party without prior commission approval. Only the commission has the authority to waive the privilege of communication, or privileged communications and work product, and you're prohibited from disclosing that without prior commission authorization. So we've had some problems in the past. It's particularly difficult for me because as a lawyer, it's that one time where I feel that I can be completely candid about the risk of liability and provide good counsel. And when I think that it's going to be undermined, it's unsettling. And so then I have to be guarded for the best interests of the entity to make sure that, and we've had to deal with that. And so it really is in the best interest of the organization that if there needs to be a disclosure of that information, then 3 of the commissioners can make that decision. If that happens, I don't have a problem. Then there's no discussion.
But it is important for executive sessions that it not be disclosed, because sometimes we're talking about employee issues. And, you know, if it's disclosed, it could result in litigation against the
Or HIPAA.
agency.
Yeah.
HIPAA, things like that.
But the other thing is that if there is going to be a waiver of, it has to be done on the agenda of a public meeting. So we need to know in advance. And then that's the same thing with exempt public records. Under the Idaho Public Records Law, there is a series, a litany of exempt records, public records that are exempt from disclosure. And only the body of the commission can, if anybody even wants to look at them, the commission has to authorize it.
But we can't make any decisions in executive session, and that's absolutely critical. If we deliberate towards a decision, that has to happen.
So now we have some miscellaneous provisions of our protocols. This is where the real good stuff gets real juicy, and that is it relates to the standards of conduct of the commissioners. It also incorporates the district's ethics policy and personnel policy. By statute, you are all employees. You know, while you sit as an elected official, you're an employee by law. And so you share the same status of employee in employment law. Now, you can't be fired. The only time you can be fired is if you are recalled or elected. But there are other things that can happen, and we'll go through those. But at the same time, what the conduct of a commissioner can have lots of risk of liability for the district through harassment, those kind of things. So here's the standard of conduct. First one, of course, comply with protocols. Please do that. Comply with our district's code of ethics. Comply with and enforce the district's personnel policy. You're not allowed to treat any commission employees abusive and unprofessionally. I won't say any names. Not willfully or knowingly circulate public or exhibit any false statement or presentation concerning ACHD commissioners or employees. Not willfully neglect or fail to perform faithfully a duty imposed by law. Not act in an arbitrary and capricious manner. That one we have you need to be diligent in establishing a record based upon facts and the law, not based upon your political agenda. No, you don't commit an unlawful act, you don't act inconsistent with your official duty, and you don't violate your oath of office. Boy, we went back to that one, didn't we? So, what happens? You violate your code of conduct, the commissioner violates it, may be punished as prescribed by the state and federal law, including forfeiture of office. That's the oath of office and some ethics. But the commission, independently of all of that, they can adopt a public censure statement admonishing any violation of these standards of conduct. That has never happened that I recall. I know we've been close a couple of times, but we've never done that. That's a pretty extreme deal. Here's some additional standards of conduct. So in state statute, the district shall be liable for the actions of commissioners, officers, agents, and or employees of the district when the commissioners, officers, agents, or employees are performing their duties. So there you represent a agent of liability. So don't be responsible.
Can you give us an example of that? I mean, HIPAA requirements, I think, would be an example. If a commissioner knows about an employee's medical situation and says something, couldn't that be a HIPAA violation?
Oh, yeah.
That then hold not only that commissioner, but the whole district liable?
Yeah, it can be employee related, it can be violation, I mean, even getting into undermining eminent domain, saying things. There's so many different things. We've seen, if Sherry was here, her eyes would roll. We've seen a whole bunch. And I'm not talking about commissioners necessarily, but we've seen a bunch of things. But the important thing to know is that as an elected official, I hate to break the news to you, but you don't have a halo over you. You're definitely an agent, and your actions can negatively impact the highway district. So that's all you need to know, and I'm sure Commissioner May, that you, based upon your tenured past, you'll do your best. And then within our standards of conduct in our personnel handbook and ethics policy, all employees are expected to discharge their responsibilities faithfully, willingly, and to maintain a courteous, friendly, and cooperative attitude toward fellow employees and the general public. An employee is prohibited from engaging in any conduct that would reflect unfavorably upon the district service and must avoid any action which might result or create an impression of using public office for private gain, giving preferential treatment to any person, or losing impartiality in the conduct of district business. We have actually terminated employees over this provision.
So there's exceptions for elected officials, which also creates some sensitivity, because we go out and raise money for re-election.
Well, we'll get into that.
And so there's this sort of other employees, they can't go out there and raise money, but we do, from the very people who have business before us. And so there's that interesting dynamic, because we don't have a planning and zoning commission is the initial finder of fact, like a city does, where it's separated out. City officials go, elected officials go out and raise money for people, but the initial finder of fact is the P&Z. Here, we're both the P&Z and the commission and the council, so we make findings of fact on people who have given us money.
Yeah. And then we also have something within the subsection of this that talks about being discourteous or rudeness that would affect the district's goodwill. Commissioner Goldthorpe, I won't point you out, but I'm just teasing you. You've been so quiet, I feel like I have to poke you.
Well, yeah, I'm pretty big on courtesy. So.
I know you are. That's why I did it. So here's additional standards of conduct. Our code of ethics prohibits engaging in conduct that is based upon we're in a situation where commissioners' private interests may affect or appear to affect their objectivity, independence, or honesty in performing their official duties, which includes acts of reprisal. You have to be able to make a decision that shows, throughout the decision, you have to regulate yourself that you could be fair and impartial. And it isn't based upon a friendship, it's not based upon anything. You know, it's one thing to have people support you for your political office, but at the end of the day, that's where it stops. And you need to listen to the facts and look at the law, and you need to act as like a judge and a jury. You need to act independent of that. And and it's a violation of code of ethics, and there are people who have been tripped up on that. Then it's clear that ACH adopted require the commissioners to conduct themselves in accordance with the highest professional and ethical standards. The standards of conduct require each commissioner to treat any publicly elected official, employee, or any member of the public in a respectful, professional manner. You guys all do that.
Not just ourselves, but all other elected officials.
So now, the protocols.
What I'd like to do, commissioners, with your permission, why don't you take about a 5 to 10 minute break? The facilities are right over here. You can start your lunch if you like, but we're going to continue to work through this if that's all right with you.
We're halfway.
Yeah.
Let's do about 10 minutes.
Okay. Again, the restrooms are through that door.
Well, let me finish. Is there any questions on the protocols? Straightforward. Okay. Good.
Very straightforward.
Well, the other thing, Commissioner
Very
May,
valuable.
we have an open door policy, legal department. If you ever have any question, caution is
That door.
goes a long way.
When in doubt,